Hi everyone, welcome to MOOC lecture series on democratic awareness and legal literacy. Today I am going to discuss about the concept of state and pre and post constitutional law in relation to part 3 of the Indian Constitution. Now, so far the state is concerned, all of us we know it is, we have read about the state that it is a particular definite territory having its own government with a particular population and which is sovereign one. But when you look into the scheme or the operation of the constitution, actually the part 3 of the Indian Constitution, first of all, it defines the term state, that against whom the fundamental rights can be exercised. Now let me point out one thing, that fundamental rights means the rights which are described as a fundamental within the part 3 of the Indian Constitution. Now this part 3 of the Indian Constitution, in addition to defining or prescribing that what are the fundamental rights available to the citizen, even to some rights which are also available to the non-citizen, it also provides the mechanism or it defines the terminology, that is the state, against whom these fundamental rights can be exercised. Now, all of us we know that there are different theory of state, but the most acceptable theory as it was propounded by Hobbes, Locke and Rousseau, that is the social contract theory. It says that, from nature, from the state of nature, we moved into the modern concept, that is the modern state. And when we entered into the modern concept of the state, we have surrendered all our rights to the politically sovereign authority. But certain rights we did not surrender to that politically sovereign authority, and which retains by the citizen of that particular country. Actually, these are described as the fundamental rights. Obviously, the fundamental rights are very much essential, those are very much basic, but at the same time, we must remember that all basic and essential rights are not fundamental rights as per the technical meaning of the fundamental rights is concerned. Obviously, many fundamental rights are the human rights, but all human rights are not the fundamental rights. But the framers of the Indian Constitution had an opportunity to look into the development of the UDHR 1948, that is the Universal Declaration of Human Rights 1948, and they incorporated the majority or the major portion of the concept of human rights within the part 3 of the Indian Constitution, and which fulfills both the purpose, that is the protection of human rights, as well as that is the conferment of fundamental rights upon the citizen and in some cases to the non-citizens. Now, what does it mean? When we say the term state, what does it mean? Obviously, the term state, for the purpose of part 3 of the Indian Constitution, we are not using in the sense as we use it under the political science. Here, under Article 12, the term state, it has been defined that unless the context otherwise requires, the term state means and includes the following. Number one, the central government and the Parliament of India, the state government and the state legislature, local authorities and the other authorities. Now, so far the first three items, that is the central government and the central parliament, state government and the state legislature and the local authorities are concerned, I think there is no problem as such, because we understand that what are those. But so far the other authorities is concerned, here it is a problem. Because what is the meaning of the term other authorities? The term authorities, it simply means any body which has the power to give command. But when we look into the first three things, that is the legislature, that is the central legislature, central government, state legislature and the state government, and the local authorities, that is the local bodies, for example, the panchayat, the municipal board, etc. But the term other authorities has not been defined in the Constitution, and it requires some sort of judicial interpretation. And from the year 1950 to till this point of time, the judiciary, that is the higher judiciary, Supreme Court and High Court, in several occasions, defined the term state and tried to expand the meaning of the term state, because the object of the fundamental rights is to make it available to every citizen rather than having any sort of restrictive interpretation. It was rightly mentioned by Justice Bhagwati that the object of the fundamental rights, cut. As it was rightly observed by Justice Bhagwati that the attempt of the court must be to expand the fundamental rights rather than attenuate their meaning by way of restrictive interpretation. That is why the court always try to interpret the provision of Article 12 in such a way so that the citizen they can exercise their fundamental rights against as many bodies as possible. However, initially the court took a very narrow approach. In University of Madras versus Shantabai, the case was that whether University of Madras was a state within the meaning of Article 12, the court took a very restrictive approach, and the court says that the meaning of the term other authorities are to be interpreted by following the principle of ius rem generis. That means like of the same nature or of the same kind. Now, what is defined, that is the central government, central parliament, state government and the state legislature and the local authorities, the university does not come within the purview of the same categories. And that is why the court held that no, University of Madras is not a state within the meaning of Article 12, and that is why you can't enforce the fundamental rights against the university, though there is a violation of fundamental rights by the university itself. And that was a very restrictive interpretation. However, in Rajasthan State Electricity Board versus Mohanlal in the year 1967, one opportunity arose where the court tried to interpret the term state in a very broader manner and looking into the structure of the organization rather than mere following the principle of ius rem generis. And in this case, the court held that the ambit of the other authorities, it should be widened, and Article 12 should include the authorities created by the Constitution of India or the statutes or any other laws, or when the state or the state machineries, they have the control over that particular authorities, those authorities must also be included within the meaning of Article 12. And this functional identification of the state, it was again reiterated in Shukdev versus Bhagat Ram case. In this case, the court interpreted that a corporation, that whether a particular corporation is a state within the meaning of Article 12 or not. In this case, the court held that the corporations are the statutory bodies. That means those are created by the statutes. And according to the court's interpretation, if any body which is created by the statute, and when there is some sort of a statutory power and it is bound by some sort of binding rules, and there is a pervasive control of the government of that particular body or the organization, then obviously it can be termed or treated as a state within the meaning of Article 12. And more importantly, in Ajay Haisia versus Khalid Mujib, the court actually pished upon the justice and found that that the concept of state, there is no reason to restrict the meaning of the term state. Rather, the court said that we must interpret the term state on the basis of many criteria, and the court fixed certain guidelines, and one of the most important guidelines which the court fixed, that is the functionality test. And the court said that when there is some sort of control over of that particular body or of that particular organization, then obviously that can be treated as a state within the meaning of Article 12. Now, the most important thing is that violation of right, whether it is a fundamental right or it is mere legal right, it is always a problematic aspect. Now, if we put a very restrictive meaning of the term state, and if there is a violation of fundamental rights by that particular body or by that particular organization, then obviously it will be a problem for the citizens. If they take the plea, if it becomes a defense, because the fundamental rights, these are nothing but the limitation of the governmental power, that the government, even the government wants to do something, the government can't do. The government can't excess its power, violating the fundamental rights of, as prescribed in the Constitution of India. However, if we look into the plethora of judgment given by the Supreme Court and High Court, there was some sort of inconsistency so far the interpretation of this particular concept, that is the state, is concerned. For example, in KM Thomas versus Cochin Refineries Limited, the court held that refineries are not the state because private individual could have a substantial control by owning 26% of the shares. Now the question is that these refineries, if these are not state, only because of this particular criteria, and if there is any violation of fundamental rights, then how to get the remedies? Can I get the remedies under Article 226 or under Article 32 before the Supreme Court and before the High Court? The question, it becomes quite important. Similarly, in Chandar Mohan Kharna versus NCERT, in the year 1992, the issue was that whether NCERT is a state within the meaning of Article 12. The court concluded that it is not a state and it is autonomous. Now, though acknowledged by the court that in fact, it exercises some sort of supervisory function and it has some sort of governmental control over it, particular this organization, it has some similarities or some credentials through which we can treat that yes, it is a state within the meaning of Article 12. In J.P. Unnikrishnan versus the state of Andhra Pradesh, again, the educational institution, it was in question that whether educational institutions are the state within the meaning of Article 12. The court in this case particularly held that education is a public function and every educational institution who are imparting education, actually they are imparting or they are dealing with the public function as a whole. However, by this reasoning, all colleges and schools will be considered to be a state as per the Unnikrishnan judgment. Now the issue is that the enforceability of fundamental rights which are enshrined in Part 3 of the Indian Constitution are majorly depends upon the concept of the state. If the concept of the state is large, if the concept of state is very much inclusive one, then obviously the scope to protect the fundamental rights become much more large and it becomes much more operative. The Supreme Court has taken different approaches while interpreting the concept. For example, when the court in University of Madras versus Shantabai, the court adopted the principles of Isasdem Generis, or when subsequently the court took the functionality test, there is a large gap. Rather, we can say that the Isasdem Generis, it was a very narrow interpretation of the term state, whereas the functionality test, or the test as developed in Ajay versus Khalid Mujib case, this was a quite broader one. The initial phase, the court relied upon the Isasdem Generis, but subsequently the court interpreted, as I said, that in order to facilitate or in order to give the benefit of the fundamental rights, the court interpreted the term state in a very wider manner. Gradually, the court moved towards the structuralist and then the functionality approach. That how, the structurally how the organs or this particular organization is working and what are the functions those are discharging. Obviously, the concept, the widening concept of the particular term, that is the state, it is a very broader one and it should go a long way in order to facilitate the protection of the fundamental rights which are available to the citizen, as well as some rights which are also available to the non-citizen. After discussing the concept of state under Article 12, let us move to the discussion of the next article, that is under Article 13, which talks about the definition of law, obviously, and it also talks about the pre and post constitutional law. Now, the political science definition or the science, the definition of the term state as we use in the political science, it is not only about the definite group of people. Rather, in the constitutional perspective or from the constitutional law perspective, we try to define the term state from a broader perspective, that means all the organ of the state. And the basic purpose of the fundamental rights are that the state can't make any law in order to take it away or in order to curtail the fundamental rights. Obviously, let me point out here that no right under the Indian Constitution is absolute right. Every right, it can be restricted, it can be regulated at some point of time, but following the procedure of the provisions of the Constitution. The Constitution is the Grundnorm, or it is the basic law, and you can't take any decision, or you can't take away any rights, or you can't make any law which are contrary to the provision of the Constitution. And if there is any such act, then obviously the provisions of Article 12 we can apply, and we can challenge the decision or the particular lawmaking power of that particular authority. Now, obviously, before having the Constitution, we were ruled by the Britishers for more than 200 years. Now, we can't expect that all of a sudden we will get a legal structure just by way of enacting a constitution. It takes some time. It requires some infrastructural support, some human resources, and obviously the time, of course. Now, the Constitution also provides, the mechanism that what we should do or what would be the principle we should follow in such a case of vacuum. Just imagine that after independence, the Constitution, we got, and the Constitution becomes effective. Now, obviously, before the Constitution becomes effective, there are thousands of laws or the hundreds of enactments which were in existence, and we, the people of India, that is the native Indians, we are governed or ruled or adjudicated by those laws which were made obviously by the Britishers. Now the question comes that what will happen to those laws? The laws which were framed by them, but at that point of time Indian Constitution was not there. At the same time, again another question will come that after the enforcement of the Constitution, what would be the limitation of the legislative power? Whether the legislature, after that body incorporated, because all of us we know that Constitution, it defines the different organs of the government, it prescribes the power, and it also prescribes the limitation of the different organs of the government. And the different organs of the government, basically three, that is the executive, legislature, and judiciary. The legislature makes the law, executive authority execute the laws, and the judiciary adjudicate the matter when wherever or wherever there is any break or there is any breach of law, the matter will be adjudicated. Now, what will happen? Whether the parliament, upon the parliament, is there any limitation so far the lawmaking power is concerned? The answer is yes. We have the concept under the Indian Constitution. Actually, Article 13, it provides or it prescribes, it works just as a shield to the fundamental rights. If we look into very carefully the reading, that is, the Article 13, the effect of Article 13 is that any law passed by the legislature, or any law which are in existence or which were in existence before the enforcement of the Constitution, which are violative to the provision of the fundamental rights, are void. Now, if we discuss this Article 13 part by part, in order to get the idea very clear, you can find that Article 13 Clause 1, it talks about the pre-constitutional laws. That it simply says that all laws which were in the territory of India immediately before the enforcement of the Constitution, in so far as they are inconsistent with the provision of this part means part 3. And as I already mentioned, that Article 12 says that for the purpose of this part, the term unless otherwise requires, the term state means and includes the central government, parliament, state government, state legislature, other authorities, local authorities, and then other authorities. Now the question is that when the law has been passed or when the law was in existence, if the law becomes violative to the provisions of the Indian Constitution, more specifically the fundamental rights part, which are enumerated in part 3, what will happen to those laws? It says that the laws which were in existence before the enforcement of the Constitution or before coming into existence of this particular Constitution, those laws shall be treated as void if any of the laws, existing laws, contradicts to any provisions, that means the fundamental rights provision of the Constitution. What I am trying to say, or rather the framers of the Constitution, they tried to point out that obviously all of a sudden you can't have a full-fledged legal system. We are already in a legal system and there were some laws. Now those laws, if those fulfill the constitutional objectives, if those laws are not contradictory to any of the provisions of the Constitution, more specifically the fundamental rights provision of the Constitution, then there is no need to be worried. Actually, those laws can be enforced. But if there is any existing laws which are violative to the provisions of the fundamental rights, then the law is void itself. That means we can't follow this law or we can't adhere these laws. Now, Article 13(2), if we look into this particular provision, it deals with the post-constitutional laws. And it says that the state shall not, please I repeat the word, the state shall not. That means the state under any circumstances is not permitted to make any law which takes away or abridges the right which has been or which rather have been conferred upon its citizen, that is the fundamental rights. And if the law has been made by the authority, that is the legislative authority, and at the center it is the parliament, at the state level it is the state legislature, if it makes any law which violates the fundamental rights, then to the extent of that contravention, the law is to be treated as a void one. So here we are getting the both scenario, that is the post-constitution and pre-constitution, and the most important aspect is that in both the circumstances, the intention of the framers of the Constitution is that under any circumstances, the fundamental rights cannot be taken away, the fundamental rights cannot be limited, or the fundamental right, the parliament or the legislature, can't make any law, which, minimize or abrogate the fundamental rights concept. Now, the question comes that why these fundamental rights, are to be protected in this manner, that is through the constitutional provision itself. First of all, fundamental rights, as I already mentioned, that it works as a limitation, upon the governmental powers. And fundamental rights, when you say that the post-constitutional law, any post-constitutional law which violates the fundamental rights are void ab initio, actually this particular principle is not universally applicable. Because in the constitutional scheme, if we look into the subsequent provision, then you will find that some rights are available only to the citizen of India, but some rights are available irrespective of any citizenship criteria. For example, rights that apply all persons. For example, Article 14, okay, right to equality. Article 21, that is, right to life and personal liberty. These rights are available against all people, against all citizens, all people, irrespective of its of his or her citizenship. But when we look into Article 19, this is available only to the citizens. So the applicability of the doctrine that the in case of post constitutional laws, the principle, that is the void ab initio, it has no universal application. Rather, it can be navigated or it can be amended, as to the requirement or as to the governmental policy. Now, after discussing this particular thing, one particular observation can be made, that a law which contravenes the right, it must be examined through the constitutional provisions. That the constitutional, whether this particular law contravenes the constitutional provision or it doesn't, it contradicts with any of the settled principles or the provisions of the Constitution. Even if we look into Article 13(3)(a), it defines, it is quite interesting that nowhere the term law has been defined. But under, Article 13, Clause 3, Subclause A, the term law, an attempt has been made by the framers of the Constitution to define the term law. And it says, I quote, that any ordinance, order, bylaw, rule, regulation, notification, custom, or usages having in the territory of India the force of law, unquote. So this law, actually whatever you describe in the name of law, ultimately it must have the enforceability or it must have the force of law. And here, for your understanding, I can say that is having the force of law, it simply means that it is enforceable. You can adjudicate upon it. You can go to the court in order to enforce it, or in order to clear, or in order to carry forward the mandate as required by the provisions of the Constitution. However, the concept of delegated legislation has not been covered under Article 13 Clause 3, but these are the different issue which can be covered, another public law, another branch of public law, that is the administrative law, within the subject of administrative law. Now, in addition to this particular post-constitutional and pre-constitutional, in both the circumstances when it talks about that it comes into contradiction with the fundamental rights, etc., etc. But let me point out that the Constitution of India prescribed a very detailed framework so far the legislative power is concerned. The 7th schedule of the Indian Constitution, it has 3 lists. That is the list 1, list 2, list 3, also known as the central list, that is the state list, and the concurrent list. And all the lists in this 3 list, except entry 97 of list 1 of 7th schedule, all the entries are very much specific. And upon the subject matter which are enumerated in list 1, the Parliament can make law. In list 2, it is the state legislature can make law. And in case of the concurrent list, it is the both, that is the central government, that is the central parliament, or the parliament, that is the central legislature, and the state legislature, both of them can make the law. Now, you might have a question that what will happen if there is any contradictory as to the law made upon the same subject matter both by the state government and the central government. In order to clear this problem, or in order to resolve the issue, we have the rule, that is the provisions under Article 254, that is the rule of repugnancy. We can apply this particular principle. This is a different topic. I am not entering into the detailed discussion of that. But keeping in mind the entire scheme of the legislative provision, I must tell you that it is not only the fundamental rights aspect, or in a better term, if I say that it is not only that the violation of fundamental rights only render the law or the legislative action as invalid one. There are certain other grounds also. For example, if we look that the violation of the scheme, as I said, that if the Parliament makes the law in relation to a subject matter which is mentioned in list 2, in that circumstances, obviously the law will not be valid one. That means there is this particular discussion, I think, already has been made, that we are following the principle of federalism. And one of the aspects of federalism is that there is a clear distinction of power, and so far the legislative power is concerned, it is very much prescribed through the constitution. For example, the statutes, you are making the law, but it is not coming within the legislative authority, or the statutes which offend the constitutional restrictions or the prohibitions. When the lawmaking authority, they are making the law, violating the provisions of the constitution, then obviously then the law will be treated as a void one. Now, a statute to be valid, they must follow certain principles. That is, it must go through a particular legislative process. And this legislative process, which are very much detailed in the, from Article 245 to Article 255 of the Indian Constitution, read with, Schedule 7, that is, there are 3 different lists and the different subject matters. Now, in case of legislative body or the legislature, they exceeds its domain of the legislative authority, the law would be declared as an unconstitutional. Because, Indian Constitution or India as a country, it is the rule of law. It is the basic features of the Indian Constitution. And the rule of law means where the law rules, not the man. And here every organs, the constitution of the every organs or the composition, constitution, power, function, limitation, all are very much specified through the constitution. So if the legislature exceeds its power, then it will be treated as unconstitutional. And if there is any lack of legislative competency, then also it will be treated as unconstitutional. Even obviously there are certain grounds that on the basis of the wisdom of legislation, when the law has been passed by the legislature, it is not necessary that the legislature must have the wisdom, and on the basis of the wisdom you can't challenge the basic principles of this particular lawmaking power. Now, so far the discussion of the concept of the state or the validity of the law is concerned, actually the judiciary in India has played a very vital role, and to a large extent, secured the rights of its citizen. Judiciary, it remains quite proactive in serving and maintain, to maintain the delicate balance as prescribed by the constitution itself. Very recently, for example, if we look into the Shaira Banu case, where the judiciary, stepped into the questions, of the personal laws in order to uphold the constitutional value of non-arbitrariness. The recent judgments like, Joseph Shine or Navjot Johar case, these are the example of the judicial dynamic interpretation, where the court, uphold the constitutional values. The court took into account the evolution of the society, the changing circumstances, as well as the present constitutional values, and conclude that the law in question, it must be socially relevant, it must be progressive one, and it must, very much forwarding, it must be forwarding in nature. That means, with the passage, with the changes of the time, the law has to be changed. Law can't be static. Which one at one point of time which was treated as a law, maybe the time may come, or the time has come that to change the law. Now, in such a circumstances, the judiciary must not shy away for invalidating any particular law, which has been passed by the legislature. Whatever the argument may be, the Article 12 and Article 13 together, lays down the foundation or the founding basis for the entire discussion of the fundamental rights. Obviously, we are very much concerned about the right, but I must also request all of you that while discussing or while understanding fundamental rights, please look into the fundamental duty also and try to understand that how the judiciary incorporated the higher norms in order to interpret both the concept, that is the state, and the constitutionality of the laws. With this, I want to conclude here. Thank you very much.